and Guidry goes, let's go look at something that took place 40 years ago. Who cares? Okay, that's political.
Good evening. On behalf of International Broadcast Media, IBM Television, welcome to The Lawyer's Den. This day, we are tackling the very tough subject of the concluding, closing arguments in the trial in Minneapolis that is going to have repercussions around the world. So, with that in mind, I know there is someone out there that we missed last time, and that I'm hoping might be here to help me guide this conversation. Nick, are you out there?
I am not. I am not present. I am not here. No. Okay. I deny. And I'm taking the fifth on everything.
You mean deny, demur, and...
Yeah, right. I deny, delay, don't pay. That's what attorneys do, right?
Right. Well, that's what our clients do attorneys.
Oh, right. That's true. Okay. Well, we have a lot of attorneys here today, don't we?
Yes,
on Lawyer's Den? Okay.
Yeah, Nick, you want to do the honor?
Well, bring some in. We'll bring this gentleman in. He is a real attorney. He's actually practices law in the state of Utah. He has a JD from BYU University, which is Brigham Young University, and also an LLM from Georgetown University. Our constitutional scholar has joined us. Now let's welcome Jeff Teichert to the show. Jeff, welcome to the show.
Thank you very much, Nick.
Okay. Yeah, we're flooded with lawyers today on the Lawyer's Den. It's like one of those things. And also we have from New York City, who went to State University of New York in Albany, and also practices law in the Big Banana, otherwise New York City. He is the street fighter. Let's bring in our fighter, Fernando Leal. Fernando, welcome to the show.
Thank you. Okay. Nice to be back.
Okay, I think everybody's here now, Bill. What's our topic?
No. We don't have everybody yet because
we don't. We're missing. All right. Well, I was trying to. Okay, so all right. Okay, so we'll bring in this guy, this gentleman, and I use this term very loosely. He actually went to the University of Southern California, received his bachelor's degree, then went on to The Ohio State University, received his law degree, picked up a criminal law degree in Alabama, which is I think a hotbed of criminal law, excuse me, and then went to receive his LLM from NYU and now is a professor at Georgia College. Let's bring in our famous Professor Adam Lamparello.
Great to be here. Thanks, Nick.
He even acts like a professor. Gosh, can you believe that? Great.
Yeah, I know. Also,
very serious. Yeah, very serious and all that stuff. Yeah. Now we have somebody who's our on-the-road attorney. She's actually from Lithuania, then went to the United States of America, which is our country for those people who are listening worldwide, and received her law degree from the University of Denver and a master's in law, LLM, which is a teaching degree she received from the University of Denver. Let's bring in one of our favorite attorneys, Guidry Tonite. Guidry, welcome to the show. Okay, so now we have the real problem of tonight, which of course is going to be introduced by our attorney, who also practices law in Washington, D.C. He is the Den Master, Bill Trezevant, the Honorable Bill Trezevant, Mr. Bill.
Okay, well, as a point of order, if I may, first, I want our audience to know, because I think it goes unsaid so many times, that Nick is a 3-time state champion in chess in the state of Florida. On top of that, he has a very successful career handling all of the silver spoon people that have lots of money, which is why he has lots of country clubs. But we do not hold that against him here, because you know why? He keeps it real for them, and as a result, keeps it real for us. Now, Guidry, I really have to get up to you, because right now this is called, commitment. Pulling off to the side of the road and showing up, all delightful. Now, what we have tonight is simply this, and there's no other way around it. We had closing remarks and arguments today in the trial in Minneapolis. And some might say that that is maybe the shot heard around the world in the Black Lives Matter movement, and or if there is a change in the way we look at policing the way we think about ourselves, the way we think about self-governing. We don't know. We certainly did not know that in front of a store called Cup of Cakes or Cup of Foods, that this was going to happen a year later. But now we have the whole world watching, and we have the jurors in Minneapolis sequestered, making a decision. So for our purposes, they will not hear what we have to say. Now, for our audience, nationally and internationally, we've chosen to do it this way. We're going to open with Jeff as a summary for the prosecution. We're then going to go to Adam for a summary idea of the defense. Then we're going to do our round robin, and then we're going to see where this conversation takes us. It's really important. It has worldwide implications. And Jeff, I turn this over to you from the West. Jeff, please. Mute, Jeff.
The primary arguments presented by the prosecution are that this is an easy case, that the police officers knew George Floyd was in serious trouble, particularly Chauvin, who was the one with his knee on Mr. Floyd's neck for 9.5 minutes, that he kneeled on his neck while the guy first struggled and pleaded for his life. And then when he lay there motionless, he continued to pin him down to the ground while he was motionless and handcuffed the entire time. And they're saying, you know, that this is an open and shut sort of case. I have said at times that O.J. Simpson would have been convicted in a 2-week trial. I don't think the prosecution made the same mistakes in this case that the prosecution in that case did. I think Chauvin is going down. He also, I would point out, didn't take the stand. Now, that cannot be held against him by the judge or jury in this case, but it's just a noteworthy thing. I'm not surprised he didn't. Most defendants don't. But I think in a case this serious, maybe he should have gotten on the stand and told everybody he didn't do it. He didn't mean to hurt the guy, whatever. But
okay.
I think they knew he'd be barbecued on Cross-X if he did that.
No, you're right. But, you know, Jeff, what I found curious about that, and I just want to drill down on this one piece, and that was, I mean, did you think it was like a stage piece of a theater when his attorney asked him like it was a real big deal? We've talked about this. We've discussed this. And have you had thoughts about this? I mean, that for me was just like, I mean, unnecessary and never happens. I've never seen that when asking a defendant whether or not they were going to invoke their Fifth Amendment rights, followed up by the judge asking him in a very dramatic fashion, pulling off his mask and going through that. How did that strike you, Jeff?
Yeah, I'm not sure why it was needed or how it helped anything. It reminded me a little bit of the prosecution in the O.J. Simpson trial, to invoke that one more time, when they asked Mark Furman, how do you feel about being here in the courtroom today?
Right.
It's kind of ridiculous, you know, how Mark Furman felt at the time and what his emotions were had absolutely nothing to do with the trial. If anything, it stained the prosecution by embracing him so much when facts about his racist history came out.
Okay, well, we're going to get back to that. Now, if we can turn the page quickly. Adam, you are up, and can you please, for our national and international audience, give us, because you are an esteemed criminal defense expert, subject matter and otherwise, tell us what the defense said, and then I have some follow-ups. Adam?
We've all seen the video of Chauvin kneeling on Floyd's neck, and I think most reasonable people would say it's very disturbing. But let's be clear about something. To hold someone criminally responsible, you have to show that their actions caused the death of another person. What the defense is arguing here is that Chauvin's actions, however deplorable they may be, did not cause Floyd's death. And they're saying that for a few reasons. First, Floyd had a potentially lethal dose of fentanyl in his system, and the Hennepin County medical examiner specifically said that if Floyd had died at home, he would call it an overdose. He also had methamphetamines in his system. He had heart disease. He had 90% blockage in his arteries. He was COVID positive. He had high blood pressure. And through resisting arrest, I think we can all see that those conditions were likely exacerbated. He also passed out in the car that he was driving before the police came to him. And quite frankly, the asphyxiation theory, the defense is attacking too, because Floyd's oxygen saturation level was 98%, which suggests that he not only could breathe, but he could talk, and that was not the cause of death. So the collection, the cumulative effect of all these different things, the heart disease, the blocked arteries, the methamphetamines, okay, the fentanyl, which was in a lethal dose, they're saying was the cause of death. Now, having said that, is a conviction likely here? It may very well be, but I believe it's going to be on the least severe charge, second-degree manslaughter, or it could be a hung jury or an acquittal.
Okay, Adam, I just have to ask you, because you skipped this one defense argument, and that is the exhaust pipes from the truck. Please, how did the defense argue that and incorporate that as part of plausible deniability? I mean, literally, and no, I am holding on to my objectivity, but tell me how the exhaust pipes contributed to the argument that you just made.
The experts for the defense were arguing that the fumes from the exhaust pipe, coupled with the lethal dose of fentanyl in Floyd's system, coupled with the methamphetamine in his system, coupled with his heart disease, coupled with his atherosclerosis, which had 90% blockage in his arteries, all of those things, coupled with his high blood pressure, collectively was the cause of death. And there is some evidence to suggest that it was, because Floyd said repeatedly that he couldn't breathe before he was ever on the ground. So this is the issue. To find someone guilty, you must show they're guilty beyond a reasonable doubt. And these alternative factors, when taken individually and collectively, suggest that there's reasonable doubt as to the cause of death. And that's why I predict there will be either a hung jury or at best a conviction on the least severe charge, second-degree manslaughter.
Okay. Well, now that we have that in the record books and we have it framed for our audience, if we can bring the rest of the panel up, I want to go through. I want to start with Guidry, because you're on the side of the road. I want to come to Fernando, and then Nick, I'm coming to you. Any part of that passed the exhaust pipe smell test for you? Guidry?
Well, you know, the bottom line here in this particular case that there are a lot of holes. The whole process, the whole trial had a lot of discrepancies. I think it will make, in either case, it will be a good case for appeal. The judge was primarily ruling with the prosecution, which is a good sign for the defense, because they're going to be able to use it in the future. You know, right now, important thing is to separate moral and scientific testimony and the case here. And hopefully our jury will be able to do so. The defense really had to make a story that would demonstrate certain discrepancies. It is definitely not a bulletproof story that the prosecution put forward. And I think Adam puts it very correctly that I also expect a little a smaller charge than murder. In fact, I expect the manslaughter. I think for manslaughter, the prosecution did a good, solid case. When it comes to second-degree murder, I'm doubting it due to the fact that there is a requirement for separate felony to be committed. And in this case, in my opinion, there was no.
Okay, Fernando.
Yeah, on this one, I agree with Adam.
Come on.
Listen, you're trying to push this narrative that their defense was that there was the CO2 from the tailpipe, and that wasn't the defense. What the defense did pick up that there was a hole in the prosecution's medical experts, in that they did not include that in any of their records, and they did testify that it should have been. And after the fact, the prosecution tried to introduce it, and the judge did not allow it in because it would have been amounted to new evidence. The issue here is going to be, what does the jury believe? Are they going to go with the video, or are they going to go with the medical testimony? And if they go with the medical testimony, it's going to be at best, the manslaughter charge, potential acquittal. There are appealable issues that have come up. that we can see this case maybe tried all over again. There's that distinct possibility. The prosecution, in their rebuttal, called the defense's expert testimony a story. It's not a story. They put forth opinions, and they also took personal shots at Eric Nelson. That those could be potential issues, and it seemed that they overreached a little bit.
Okay, well, that's all on appeal. But Nick, seriously, I mean, we've heard from Jeff, we've heard from Adam. Guidry sounds balanced, although but Nick, do you want to believe what's written, or do you want to believe what your eyes saw? Nick, please.
I'm not like these attorneys that are apologetic for, like Adam, for this poor police officer who's digging his knee into the guy's neck for 9 minutes and say, oh, there might be reasonable doubt that he died of something else, while the guy's stomping on the guy's head. Come on, Bill. It's first-degree murder, if not second-degree murder. At 9 minutes, I'm sitting there taking a sledgehammer and pounding Adam's head for 9 minutes, and while I'm smiling at the camera, and you guys say, well, I'm not sure if he's guilty or not. Come on, Bill. The guy's guilty of sin, and he needs to hang for it. I mean,
whoa.
Okay, he's not going to hang because we don't hang him in the United States.
All right,
we just take him to a nice jailhouse where he's going to spend
no.
I wouldn't have anything to do with this guy. Did anybody watch those 9 minutes? I hope the jury did.
Well, okay, well, fine.
And you lawyers are going, oh, well, there might be some reasonable doubt. There ain't no doubt there, buddy. You take a ball pin hammer and you slam somebody's head with it for 9 minutes. There ain't no doubt.
Okay, well, actually, Nick, I thought it was illustrative and informative that Fernando was already thinking about appealable issues. That big one, because but Jeff, seriously, and Nick, it was 9 minutes and 29 seconds.
Oh, even more than 9 minutes.
No.
Smiling at the camera while you're pounding the guy's head in. Great.
6 of which were justified based on his resisting arrest.
Adam,
yeah. You saw him extremely resistant for.
No, I'm based on
Adam,
Come on,
I'm coming. Nick, see, you guys just are inflammatory. I was going to
Not
go.
inflammatory. I'm just stating the facts. Why this guy's trying to dance around like a lawyer.
All I know is that Nick is absolutely guilty for the citation he received last week.
Okay, well, okay, fine. Jeff, I'm coming to you. Adam, I'm coming to you. But Jeff, I want you to address this one thing, because they did show in the prosecution's closing argument that when they were doing, I don't know if it was the portion when they were doing indifference, when the defendant was picking stones out of the tire of the truck while he was ignoring the "I can't breathe." So, Jeff, I'm asking you for that thought, and then Adam, I am coming to you. So please don't interrupt, if that's okay. Adam, can you restrain? Jeff, please.
Yeah, well, I mean, it is shown that George Floyd said, I can't breathe something like 23 times. Now, Adam will tell you that some of these times are before he was put on the ground. Then my question is, if he's been saying that he already can't breathe for 23 different times, and some of these were before he was put on the ground, why are we kneeling on his neck? If we know he's already compromised in some way, why are we taking risk with his life like that? There is very contradictory testimony regarding the medical evidence. In his summary, Jerry Blackwell, the prosecuting attorney, said, "Why are we talking about pills that are not in his system?"
Right.
And what we know that what's in his bloodstream already. And he goes ahead and talks about testimony that the guy had an opioid addiction, but that the drugs that are being claimed by the defense really weren't in Floyd's system. I think it'll be interesting to see what the jury does with that. Blackwell later reiterated that there was no sign that Floyd died of a heart condition. Mm-hmm. I would point out also, Adam knows this full well, that they don't have to prove that Chauvin intended to kill George Floyd to get a conviction for second-degree felony murder. They only have to prove that he committed a felony, and the prosecution is arguing felony assault, which relies on the jury finding that he used excessive force on George Floyd. I think it's hard to watch that video and think that he did not.
Okay, Adam, but I have a question for you on this one, because you heard, in addition to Jeff's questions, because you're the defense guy. You defend people. I mean, you're that bright shining light, Statue of Liberty. Kind of bring me you're innocent, and I will save you. My question is, wasn't George Floyd innocent? It was over an alleged fake $20 bill, and they are now saying that a gas pipe killed him.
I know that Floyd had multiple convictions, including for felonies. I don't know if he was guilty of this offense. I'm not sure, but that's not the relevant
I want
question.
to double screen on this one. You can't get away from that one. You can't use his prior convictions or his prior behavior as to blame him for the death. And you know this. You know that you cannot in court.
You didn't let me finish my sentence.
No, you know you can't blame the victim.
Okay, well, I'm not blaming the victim. What I'm doing is I'm being faithful to the rule of law, to the presumption of innocence, and to the standard that you must show guilt beyond a reasonable doubt. Number one, the medical examiner said he had such a high level of fentanyl in his system that if he had died in his home, he would have called it a fentanyl overdose. He also had methamphetamines in his system. He passed out in the car. He also had heart disease, hypertensive disease, high blood pressure, atherosclerosis, and was COVID positive. The question is this: did those factors, when taken together, create the perfect storm that caused his death?
Okay, no.
And the issue is, did it create a reasonable doubt about causation? And if it is,
Adam, I just want to ask a question about some of the facts.
And by the way, there were 0 injuries on Floyd's neck, in case you're wondering. And the video shows that Floyd's knee, that Chauvin's knee, was on his shoulder for a part of the time, and it shows, due to Floyd's resistance, that at least the first several minutes of holding him on the ground, after he said he couldn't breathe before he was on the ground, and after he said he wanted to be on the ground, was a lawful restraint.
Adam, I want to ask you specifically about facts, and that is this, because I heard you earlier about the level of fentanyl, and the prosecution put up a graph during their closing arguments, and they talked about the level of fentanyl that would be considered an overdose, which is like 9.86, whatever it was. And then they looked, put up in that same graph what would be, with the normal level of fentanyl, which is like 3.8, whatever it was. And then they put up the toxicology result that Floyd had, and that was like 1.9 whatever, which was minimal compared to overdose. So that when you say he had all this fentanyl in his system, that's not what the toxicology report said. And so on that part, you just can't make up facts, Adam. I am asking you though, because I really do want to give you the benefit of the doubt with regard to what the prosecution said. And then Fernando, I'm coming to you, and Guidra, I'm coming to you. But the prosecution said that they were leaning not only on needling, not only his neck, but also on his lungs, decreasing his ability to get oxygen for over 9 minutes and 29 seconds. Now, Adam, does that change your view, or you just all defense all the time? Adam.
No, because Floyd's oxygen saturation level was tested at 98%, throwing that theory out the window. Number two, the Hennepin County medical examiner found that Floyd had 11, I believe, nanograms of fentanyl in his blood, and observed that fatalities occur at as low as 3 nanograms. So he had almost 4 times what had been seen as a lethal overdose. And you can try to cut me off, but you can't ignore the facts. If you want to cut me off, that's fine, but the facts are the facts. He had no injuries on his neck. He had a host of underlying conditions, a potentially deadly level of fentanyl, and he had meth in his system and THC, and had severe cardiac conditions. That raises reasonable doubt.
No, if you give me a minute, I'm not cutting you off. I'm going to Fernando, who I think may support you, and then I'm going to Guidra. So please, Adam, don't hog the show. Fernando, please. I'm going to disagree with whatever it is you have to say right now, because I can't even believe the fentanyl argument.
You should apologize.
Fernando, please.
Yeah, I'm waiting for you to finish prattling on. I know you're going to disagree because you like to misconstrue facts and twist them around. And the fact is that if you read the ME's final report, Mr. Floyd had 11 nanograms of fentanyl in his system. At 9%, it's an overdose. It could happen at as little as 3%. Fentanyl is a vasoconstrictor, along with adrenaline which means that it slows down the flow of your blood through your system. So it will lower your oxygenation level. And that's where you end up getting a problem. That's why the prosecution had to bring in 38 witnesses to try to prove their homicide case, which in normal homicide cases, they don't really have to do that. They don't have to bring in a medical expert to try and prop up their state-sponsored medical expert. And there's where their issue lies. Just like the issue lies with the defense that it was 9 minutes and 39 seconds or whatever it was post him stopping to move. At the end of the day, this is going to be whatever the jury, which side the jury wants to believe. Do they want to sit there and believe the video, which is why the prosecution kept playing it over and over again and hammering the point, believe your eyes, versus do you want to listen to the medical evidence? And the medical evidence knocks down some of the higher charges. You know, the prosecution has to prove each element of each crime beyond a reasonable doubt. And that's where they get into trouble with the higher charges, not so much the lower charge.
Guidry, these gentlemen would have me believe, and Nick, I'm coming to you after Guidry. But Guidry, these gentlemen would have me believe that George Floyd, who was dancing and bouncing around on a Memorial Day weekend, just having his own good time, all this other stuff, that he would have died that day, regardless of whether or not the police showed up. Now, I happen to, I don't know that it passes my eyeball test, because I don't know that a guy that's dancing around, screwing around, flirting with girls, and then just trying to get, smokes so he can go on and live the rest of his evening, because it seemed to me like he was a one day at a time kind of guy, would end up dead but for police enforcement. But, your other colleagues here tend to believe that he was dead anyway. Guidry, your thoughts, eyeball or otherwise?
Well, that was a good point, that he was dancing around, yet at the same time he appeared high. And when the police officers confronted him and tried to detain him, there were certain issues that could also go to the reason why Chauvin made such a decision. It is important to take into account that at that time during his detention, the environment was volatile. You had people, you have mobs yelling and screaming. You had a person with a prior convictions with apparently high trying to be detained, who is substantially taller and substantially heavier than the officer Chauvin. So the situation was volatile, in short. But Bill, to your point, I do think that the main factor deciding this case will be the substantial cause. It will be whether the jury will find that kneeling on his neck or the shoulder was a substantial cause to his death, meaning that, yes, such amount of drugs could cause death. Also, such amount of the drugs in the body could not cause the death. He might have lived another week, month, or so on. And that was arguing that he was used to high levels of drugs. However, if the jury thinks that kneeling on him has made his death a little bit quicker, that he could have been dancing, as you said, Bill, if kneeling on his neck had not happened, that could definitely lead to sentencing, which I think manslaughter is very realistic. When it comes to the second degree murder, I do not think that it's a strong charge, simply because it requires a separate felony. And as it was said by Jeff, that it's sufficient to have assault that would completely combine both charges, first degree and second degree, because every single felony has a degree of assault. And also I want to remind that the police officers are being charged on a different level than regular people. So meaning when that kneeling on his neck became the abuse of police force, and that's where it would be.
All right, Nick, I'm coming to you, and Jeff, I'm coming to you. But Nick, seriously, I'm going to ask you the following. We have two people for the defense located on the one side of the screen. And they're making their arguments for reasonable doubt. But Nick, seriously, I mean, your turn, Nick, because I don't see it.
Bill, is this lawyer's den or liar's den? I mean, listening to Fernando and listening to Adam, all I can think of is liar's den has now re-arrived. The liar's den for the defense, not lawyer's den. Listen, I'm asthmatic, so I'm on drugs all the time. Here's one drug, here's another drug. I got all these drugs I'm on. Some jerk who's supposed to protect and serve sticks his knee on my neck for 9 minutes, and I die, and they say, well, you could have died of this. You could have died of that. But let me tell you something. Adam and Fernando, sticking your knee on my neck and killing me for 9 minutes isn't going to help my cause. But the thing is, you're thinking, well, it's okay. Let me tell you, it's not okay, Adam. I don't want any police officer whose job is to protect and serve sticking his knee on my neck for 9 minutes. I have a hard enough time breathing without his knee on my neck for 9 minutes. And then you're saying, oh, well, he might have died of this. He might have died of that. No.
Because unlike him,
minutes.
you take your medication as prescribed.
Come on, Adam.
You're not a drug addict.
Yeah, I am. I have to be on these bloody drugs. And so he's got mental issues. He's got to be on certain medication. He's not getting proper treatment. The fault of your wonderful state. But the thing is, to sit there and let a guy like this, and you look at the guy's evil in his eyes. He's sitting looking like, look, I can do this to you, and you can't do anything because I'm a police officer. And no, it's not right. This over policing of America. I have my complaint here. I don't need that from police officers whose job is to protect and serve. And you don't believe it's to protect and serve. It's to kill whenever you feel like killing. No. This guy goes down big time. Murder 2, murder 1. I don't care. This guy needs to basically eat. He needs to spend some time in the big house for a long time.
Floyd had more drugs in his system than Elvis did.
Adam.
So what? That's totally irrelevant.
No, because they caused his death.
May I please?
So what?
Okay.
Means nothing.
Okay, Nick. Just all right, Jeff. We've given enough time to the defense. I'd like to hear from the prosecution.
Well,
I mean, you've heard all of the specious arguments, and I throw that in provocatively. Fernando, Adam, but Jeff, seriously, you have two people on the defense, and you're on the prosecution, and they won't listen to a word I have to say because they just think that I'm biased. So, Jeff, your turn.
Well,
what do you think?
Just to start and point out that the murder charge carries a 40-year sentence. The manslaughter charge carries a 10-year sentence. So this is no mere academic quibble about whether we can make the murder charge stick. Secondly, when we look at the arguments that the prosecution and defense made, here is what is persuasive to me. I'll take a totally different. He comes in to rob a bank. There happens to be a 90-year-old person there who didn't take his blood pressure medication that morning. He gets so scared when they pull the guns that he dies of a heart attack. They're in the process of committing bank robbery. That's felony murder, because in the course, there may have been all these other factors. There may have been the fact that this guy didn't take his blood pressure medication and he should have. But what pushed him over the edge? Now, you can't tell me that George Floyd was in this position and he just happened to die of natural causes when someone had been kneeling on his neck for 9.5 minutes. No sane person is going to believe that. So I think this guy goes down on felony murder. I think he gets the book thrown at him for 40 years.
Here. We finally have a voice of reason. Thank you.
No, well, Nick, you and I are different. We're not necessarily the voice of reason. Guidry, maybe you are. Guidry. You've heard what the defense had to say. What do you have?
I'm very curious. Okay, so when it comes to defense, I do think that there was a reasonable doubt. I do think that manslaughter looks much more reasonable as not murder in this particular case, and I mentioned why. I'm very curious to hear what you guys think about his decision or his attorney's advice for Chauvin to evoke Fifth Amendment right and not to testify. And I wonder, if I may ask, do you think it will have certain effect on the jury's decision, one way or another?
Okay, excellent questions. Fernando and then Adam. Fernando, two-part. Fifth Amendment. You think, well, does he invoke it? Does it help? Does it hurt? And do you think it's going to affect the jury? And then Adam, the same question for you. But Fernando, you first, please.
In terms of the effect on the jury, I have no idea. That's something that you're going to have to look at the juror's face to kind of figure out. And we weren't able to see them. In terms of invoking the Fifth Amendment, I don't see what the point of that was, but I don't practice in the area of criminal law. A defendant doesn't have to take the stand, and the defendant doesn't have to testify. You can sit there and be quiet. So I really don't, from my perspective, not practicing in that area, I don't know what invoking or not invoking the Fifth Amendment does or doesn't do in terms of helping his cause. I would have just sat there and shut up the way Gotti did and every other mobster does, that they don't invoke anything, they don't say anything, they just sit there and they keep their mouth shut and let the lawyer handle the case, and that's it.
Okay, well, see, Adam, in a rare moment, Fernando has deferred to you as a subject matter expert on this issue. One, do you tell your client to shut up and invoke the Fifth? And what impact does that have on the jury in your calculation? Adam?
It depends on the case, and it's a cost-benefit analysis depending on whether you think that the defendant's testimony and the benefits of that testimony will outweigh what the defendant will encounter on cross-examination. Here, I think they made the calculation that it wasn't necessary because they had created reasonable doubt. That's one thing Jeff doesn't talk about. All the defense has to show is there's reasonable doubt about the cause of death. And when you consider the lethal dose of fentanyl that Floyd had in his system, his cardiovascular disease, his heart disease, the methamphetamine in his system, the high blood pressure, the atherosclerosis, that was a recipe for reasonable doubt, okay? And quite frankly, what Jeff also didn't tell you is that a few months before this recent arrest, Floyd was hospitalized for 2 weeks for nearly dying of a fentanyl overdose. This is a recipe for reasonable doubt. And Guidry is 100% right, that there is reasonable doubt, and her assessment is exactly right, that if there's going to be a conviction, it's not going to be on felony murder, it's going to be on manslaughter, or it's going to be an acquittal.
All right, well, fine. Adam, you get a yellow flag for putting the victim on trial again, and we're going to you, Jeff, because I know. I mean, that is...
Now,
no, I'm not listening, Adam.
And that's the problem in this trial, is that people aren't listening.
Bill, I don't think that you get a pass on killing someone who happened to be really, really fragile and easier to kill than someone else. I think the fact that it happened in the same course and scope of conduct that the assault and the excessive force was administered makes it extremely difficult to imagine that the officer's conduct didn't put Floyd over the edge. He may have been really fragile. He may have been a drug addict. He may have had an enlarged heart. He may have had all these other problems. That doesn't mean that if you're in the middle of a felony and he dies, that you didn't push him over the edge, and maybe he was easier to push over the edge than somebody else. I still think it's second-degree felony murder because there was an intentional assault committed on Floyd when the officer knelt on his neck for 9.5
The officers had no idea he had a lethal dose of fentanyl in his system. And they were justified in restraining him because he wouldn't get in the car. Jeff, I think, is wrong as a matter of law.
No, hang on. Nick, I'm coming to you because I want to add these salient facts. And I know they may be inflammatory. I know Adam agree, but I'm really worried about
but let's get...
No, Nick, please. While he was kneeling on his neck and his lungs and his back, and the other officer was on his legs, they were picking stones out of the tires. Look, sprucing up their vehicle on the one hand. On the other hand, the defendant was telling the deceased, the murdered victim here, that his feet smelled. I mean, what is that? Nick?
What is it? Well, let's go back to your original question about him taking the Fifth Amendment, Bill. Why did he take the Fifth Amendment? Because he's a snake. And see, the thing is, the real problem on cross-examination, all the snake skin is going to start getting shedded out. With this guy had a huge history of abuse, and they didn't want that huge history of abuse to be added on top of this kneeling on the neck and killing. He wasn't no saint. If this guy was a saint, he'd say, sure, I'd take the fifth, and then have all his friends parade around him, what a wonderful person he is. And this is a rare thing that happened. Come on, Bill. He took the fifth because he needed to take the fifth, because if he didn't take the fifth, that snake would have been exposed. And that's the reason Adam's theory falls apart like the house of cards that he built it on.
And I know, Nick, and actually, I mean, it's disappointing because, I mean, Adam is so helpful with the prior notions of George's issues. But wasn't it, like 2 weeks earlier when it was then police officer Chauvin doing the same thing with the same crew of people to another person 3, 4, 5 blocks away? It was 2 weeks earlier.
So that's the reason you take the fifth, Bill, because you don't want all that.
Yeah, that person didn't die. They got up and were just fine.
No, Adam, I'm trying to make the point. If you want to drag, and victimize the dead victim here, let's talk about what former officer Chauvin did.
I want to be intellectually honest.
You don't want to be intellectually honest.
Our justice system demands that, as uncomfortable as it may be. I don't bow to the mob.
What mob? There's no mob. It's the lawyer.
The mob saying he has to be convicted of murder, even though the facts suggest there is reasonable doubt.
There is no reason.
As Guidry said.
Nick, give me a moment on this one, please. I'm going to make this observation. Guidry, I'm coming to you, and Fernando, I'm coming to you. But it just seems to me, Adam, when you say that there was a mob, I guess it was the same mob that Chauvin saw when there were 10 people in the neighborhood just looking at him and saying, hey, the guy can't breathe, there's no pulse. But I guess he thought that was a mob. I guess you thought that was a mob. But fine, don't mind me. I don't need to respond.
No, it's the mob that was looting businesses, killing minorities, destroying $2.3 billion worth of property damages by these lunatics and morons.
Fernando,
that's the mob.
Fernando, was there a mob when this was going on, as your colleague asserts?
Not a mob, but a rowdy crowd, so much so that Chauvin reached for his pepper spray because they were trying to advance on him. So, sitting here in a vacuum and discussing this without being in the real live event is real easy. But when you're there and you're feeling the heat from everybody yelling and screaming and whatever and cursing and so on and so forth, there's a reason why he reached for the pepper spray. It's in the video. It was paused on. It was spoken over by the prosecution because that didn't help them. And I'm the prosecutor. I'd do the same thing, obviously. I'm trying to shave this in my direction. But, things that we keep missing here is that they found fentanyl pills in the back of the squad car with Floyd's DNA on them. We're also missing that we're talking about felony murder and we're giving examples of robbing a bank, so on and so forth. Yeah, you go in and you rob a bank with a gun. That's a felony. Here, the maneuver is something that is taught at the academy. And although they had his trainer on the stand who trains the cops, at first on direct, he said, no. Then they bring out graphs and they started bringing out pictures. All of a sudden, he's like, well, yeah, we kind of do train them to put them on the floor, put a knee to the shoulder. It's really to the shoulder, not to the neck. But sometimes it could slip to the neck and then come back on the shoulder. So that is where it's going to take it out of the felony murder range.
Okay, Guidry, I mean, can we just kind of agree on the facts that I think we can agree on, that if there were drugs found in the squad car, that they were not in George Floyd? I mean, is that outrageous for me to say that, listen, if I found a pill on the floor of a police car, then clearly that was not in George Floyd? Is that a stretch for me, Guidry, or no?
Hopefully there's no drugs in Guidry's car.
Yeah. Okay. Well,
yes,
then what?
It's a very no, but that's a very good point. The jury and we have to look at the totality of senses. So, to my understanding, that there was an attempt by Floyd to consume as much narcotics as he could in this particular offense that drugs it's also known to the police that he was some time ago arrested or in attempt to arrest him. He actually consumed a lot of drugs, and then he was, instead of taking to the jail, he was taking to the hospital. So, and in this particular case, he might have tried to do the same thing. But yes, there has to be pay attention that the drugs, certain drugs were not consumed. However, I do not think that it's a very strong and important point to look at. I still think the point is to look at the substantial cause, and I hope that jury received sufficient indication to decide on it, because to my understanding there is a lot of fuzzy languages: proximate cause, significant cause, important cause, and hopefully the jury will be able to decide on what was the.
Okay, thank you. Jeff, and then coming to you, Nick. Jeff, fuzzy facts, drugs on the floor, carbon monoxide, I think the butler did it in the library. I mean, Jeff, really, at what point in time, a reasonable doubt? How are you looking at it, Jeff? And then Nick, I'm coming to you, please.
Well, I'll tell you a weakness that we lawyers almost all have, and that is that we start to look for a theory to explain a particular case, and the ones that we have to be more creative about are the ones that we're sometimes more attracted to. And we get to the point that we go down that path long enough and we become firmly convinced that George Floyd just died there on the ground, and he would have died no matter whether anybody had had their knee on his neck or not.
Right, for breathing. He would have just died for breathing, right? Right.
He would have just died right there no matter what anybody did to him. And that is a real coincidence, if that's really true. Now, is there any doubt? Well, yeah, if he had drugs in his system, maybe there's a little doubt. Is it a reasonable doubt? It doesn't have to be beyond any doubt. It has to be beyond a reasonable doubt. I think he died in the same course of conduct as an assault against him occurred. And whether, no matter how fragile he was from other conditions, if you committed felony assault against him, I think you're guilty of second-degree murder. Whether you intended him to die or knew he had fentanyl in his system or not, you committed the crime. You deal with the consequences, and that's what the felony.
Actually, just like that television show that some of us that are older may remember, Beretta, don't do the crime if you can't do the time. Now, Nick, I want to come to you, and I want to see if I can revive your memory about when you were pulled over and cited by, the 60 degree to 80 degree citation. Yeah, exactly. And she said because she could. Now, I mean, because I want to get to you. I want you at least to kind of give an idea to not necessarily our national audience, but our international audience. This idea of reasonableness, because reasonable doubt versus unreasonable doubt. Now, you in that incident with your cherished one, she came along. She just said, "I can't because the dog's in the car."
Yeah. She's out of his mind, just like the defense, like Adam is right now. So we have a lot of people are delusional.
Well, then Nick, what is reasonable and what's unreasonable?
Well, reasonable is what the reasonable juror says and what the reasonable judge and attorney say. Unfortunately, we have some unreasonable attorneys on this den. One of them is Adam. And let's see, the first thing he does, he goes, let's blame the crowd. The crowd had nothing to do with it. There he is. Let's blame the crowd. The crowd had nothing to do with it. Then he goes, let's blame the drugs that he didn't take. The drugs he didn't take had nothing to do with it. Then he goes, let's blame the felony. What felony? He was passing a $20 bill. Let's blame everybody except the guy who's sticking his knee on the guy's neck and killing him. Let's not go blame that guy because he's innocent, because he would have died from some other natural cause if he didn't die of the guy sticking his knee on his neck. Come on, Adam.
Nick, no, Nick.
That's not the case.
No, Nick. I want
And all the crowd was trying to do is to keep this person from dying. And this guy's going to use a pepper spray to make sure he can kill the guy. And that's not first-degree murder?
Nick,
Tell me
Nick,
about it.
I hope you get convicted of your citation.
Tell me about it.
Adam, I'm coming to you. I just want to ask one other question.
Ad hominem attack counselor.
And Nick, I mean, listen, he didn't take his knee off the neck. Even after the bystanders said so, even after one of his fellow police officers said, "Hey, do we need to do this?"
Sure.
Even after the EMT showed up and said, "Hey, can you take your knee off his neck so we can move him?"
Yeah. Can you please take your knee off this guy's neck and stop trying to pepper spray the crowd that's trying to keep you from killing people? Oh, by the way, we're not sure if he's guilty. There's a reasonable doubt. Come on. Anybody who watches this guy goes down big time, and rightfully so.
Okay.
Except Adam. In Adam's case, of course, he'll walk.
Adam, there you go.
Well,
I
with
mean,
Jet,
no, Adam. My question for you, because you're the defense. He wouldn't even take his knee off his neck, even after the EMTs arrived with ambulances and said, "Can you get out of my way so I can pick up my patient?" How do you even defend that, Adam?
I am not defending that. I am saying that regardless, if the cause was something else, then he's not criminally responsible. What Jeff fails to tell the audience is that a few months earlier, George Floyd almost died of a fentanyl overdose and was in the hospital for 2 weeks. My position is he would have died anyway. And he would have died anyway because of the combination of the horrifically lethal dose of fentanyl in his system, the arterial sclerosis, the heart disease, the high blood pressure, the methamphetamines, and resisting arrest. Floyd was a terrible, terrible person. And as much as Chauvin's actions were also terrible, the cause of death, there's a reasonable doubt about what the cause of death is. As far as Nick goes, there is no doubt whatsoever. They should convict you and throw the book at you. Thank you.
Jeff, your turn, please.
Well, I mean, Floyd was not a saint. We all know that. That's not the issue. He is dead. The person on trial is Chauvin, and he's even worse. And the thing is, yeah, if you believe, and I'm talking directly to the audience, as Adam loves to do, if you believe that George Floyd died by coincidence because of all these other factors while someone happened to be kneeling on his neck for 9.5 minutes, and that kneeling on the neck had nothing to do with pushing him over the edge, even if he was already fragile, then go ahead, if you're on the jury, and vote to convict or vote to acquit. But I'm telling you, there's no way that jury believes, outside the rarefied atmosphere of a courtroom, there is no way that jury believes that it was just a coincidence that he happened to die while he was being assaulted.
And how come he couldn't breathe before he was ever on the ground and passed out in his car?
Okay, no, Adam, you had your say so. Guidry, Fernando, please. Guidry first, Fernando, please. Guidry.
Well, first, I apologize. My internet is definitely not collaborating with me, so you are still hearing and understanding what I'm saying. You know, one thing is clear, that this trial is filled with contradiction. It's a difficult trial. It's the most famous 21st century trial. The jury members that have been sequestrated will have a very difficult time deciding. And the judge even said, you better pack your luggage and be ready to for multiple days. The key here is that the defense needs only one juror who is not sure, what to decide. And I think that is really the direction the defense was taking, or any logical defense would do. And I do think there's a special place to have Chauvin for what he did. The question is, for what he did, he was supposed to be fired, reprimanded. The question will be, was it sufficiently high to cause substantial cause for him to be convicted of murder? And we will see if that's going to happen. Here, I think jury will take a lot of human factor in it. I think it was smart that Chauvin.
Okay. Fernando, please.
Yeah. This seems to be a very weird criminal trial because it's almost like a civil personal injury trial because you're trying to tie the injury to the act. Did the accident cause the injury, and did that injury cause all the pain and suffering that the individual is suffering? Here, the prosecution, it seems in a lot of these homicide cases are pretty straightforward. Jeff shoots me, I die. You don't really have to prove the cause of death. You just have to prove that Jeff did it. Here, the prosecution had to tie the restraint maneuver to the cause of death. And that's where we're getting the problem. Because there are two alternate reasons as to why the cause of death could have happened. Is it the fact that he was on fentanyl and that he had fentanyl in his system, that he was sucking on fentanyl pills that he then spit out in the back of the car, that he was arrested in his car hanging out with his two drug dealers and he had passed out before he was pulled out of the car? You can roll your eyes all you want, but those are the facts that are in evidence. And that's where the schism happens. My hunch is it's going to be a manslaughter conviction because if you look at the elements of the crime, that's what fits what's been admitted into evidence.
Okay.
Exactly right.
Oh my God, I don't need you, Georgia, right now. Right now, I need Nick to help me kind of, land this plane because I'm rolling my eyes and I can't even be my friend of 35
At
years.
least you're not rolling on fentanyl.
Yeah, see, Adam, since he doesn't have a defense, says, well, the guy had to go to hospital 3 months ago because he had drug problems, and hence, because of that, that had to be the thing that killed him, which isn't true. I mean, the people will believe that on the liar's den. Nobody will believe that in the lawyer's den, and none of the jury is going to believe that fairy tale by watching that tape for 9.5 minutes. Now, at Georgia College, where you teach, you can sit on your ivory tower and you can believe whatever you want. Peter Pan, whatever.
No,
that's
Nick,
not what happened here.
No, he can teach his kids to make great arguments there in the ivory tower. I mean, that's all well and wonderful. But I can tell you this: in New York City, if somebody's going to die of exhaust, they die every block you walk. And so I don't know why Fernando.
Well, Bill, let's imagine this guy wasn't a policeman, and I'm outside with my neighbor with my foot on his neck, killing him. And if anybody comes close to it, I pepper him, spray him. What are they going to do? Say, well, he would have died anyway because that guy was on drugs 3 months ago. Come on, Bill.
No.
I'm going down, and this guy's going down too.
No. I do have to.
Come on, Bill.
No, Nick. I do have to do this for our audience because it is true. That, down in the state of Texas, it's still on the books. There was a law, a defense to capital murder, a defense, not, I lost my mind, not insanity, but there's a defense called he needed killing. It's on the books in Texas. And so it seems to me that is Adam and Fernando's defense in this case.
That's what they do in Georgia and New York. What can I tell you? Some of the uncivilized parts of the country.
Sometimes the truth is difficult to accept, but you must accept it nonetheless if you believe in liberty. Nick, I hope you're convicted. Bill, your bias is appalling. Guidry, thank you for the reasoned analysis. And Fernando, Jeff, I respectfully disagree, but always respect your opinions.
All right, Fernando, and then Jeff, and then Nick, I'm coming to you to land this plane. Fernando, Jeff, please. For the lightning.
Silly me that I decide to look at facts when I do these analysis. Next time I'll just go off the rails like Nick and cite to my, high blood pressure medication, which is, under the control of a doctor who administers and tells me how much to take. Not some dude in the back seat of my, Ford Focus selling me a bag of blood pressure pills.
It was Mercedes, Fernando.
I know. Unfortunately, I have a Ford Focus, not a Mercedes.
Jealous.
Floyd's doing better than I am. Or was. Right now, these are the most nerve-wracking moments of a trial when you're sitting around waiting for the verdict. This is when you really want to throw up because you have no idea what's going on. I think this ends up being a conviction on the manslaughter charges. If it ends up being a conviction on the second-degree murder charge, felony murder charge, which ties into the third-degree murder charge, I think there's appeal and a really big mess is going to start.
All right, Jeff and then Nick. Jeff, please.
All right. Well, as Fernando, as a personal injury lawyer, knows, you can have multiple causes of death and multiple causes of an injury. And in personal injury law, in most states at least, they weigh the relevant amount that, 34% was because of this factor and 28% was because of this factor. And they call that comparative negligence, or in some states, contributory negligence. But when you're talking about murder, you're talking about one cause of death, and it could be one cause among many. But if you contributed to that person's death and they in fact died, you're guilty of murder, regardless of what else was going on, what else was in the guy's system, whether he had an eggshell thin skull, whatever happened. If you contributed to his death while intentionally committing a felony, well, you're stuck with murder too. And I think that's what we've got here.
Okay, Nick, help us land this plane.
It's real simple. Chauvin, we'll see you in 40 years. And for everybody else who's watched The Lawyer's Den, we'll see you tomorrow on The Lawyer's Den. Hopefully the verdict will be in by tomorrow. See you then. And Guidry goes, let's go look at something that took place 40 years ago. Who cares? Okay, that's political.